Hello, and welcome to the introductory overview of the General Data Protection Regulation in Europe, or of the GDPR in short. In this 40-minute training, the main goal is to give you a brief overview of the GDPR and the requirements this poses for implementers in the context of Fed4FIRE Plus. Now you might be wondering, why does this really matter? Why should I give so much attention to personal data? Well, the answer in short is because the law says so. Specifically, under both Article 16 of the Treaty on the Functioning of the European Union and Article 8 of the EU Charter of Fundamental Rights, everyone has the right to protect his or her personal data. The GDPR is a binding legal framework in the EU that sets the requirements for any activity that concerns personal data. Its extraterritorial scope and the strict requirements it sets has made the GDPR the most privacy-friendly legislation and is considered a benchmark for the rest data protection legislation across the world. In short, if your activity involves personal data, the GDPR is your guidebook. To ensure you comply with the GDPR, the first thing you need to understand is when exactly this is applicable. In terms of subject, the GDPR lays down rules relating to the protection of natural persons with regard to the processing of personal data, and rules relating to the free movement of personal data. Personal data is basically any information that relates to an identified or identifiable natural person. To answer yourself whether an information can directly or indirectly identify a natural person, you have to assess whether a specific natural person can be singled out even if you don't know his or her name. However, to correctly answer this question, you need to consider how much a possible identification will cost you, how much time you will need to achieve it, and whether the available technology makes identification easy or not. In the context of the GDPR, each natural person is called a data subject. Thus, any living human being, no matter if he or she has legal capacity or not, is a data subject and has certain rights and freedoms you need to respect during the testbeds. Since only natural persons are data subjects, this practically means that deceased people have no data protection rights, neither companies when it comes to company data, like the headquarters address or a company email. As personal data could practically be any information as long as it can identify a data subject, the possibilities are endless. The most common examples of personal data are listed below: name, birth dates, location data, home address, voice recordings, mobile numbers, cookies, IP addresses, criminal convictions, and any data that reveal the economic status of a data subject is personal data. Special categories of data is a subcategory of personal data and include data that reveal the data subject's gender, sexual orientation, racial origin, political opinion, health data, genetic data, or biometric data. As we will explain later, this category of data deserves higher protection due to the sensitive nature of the context it reveals. Another subcategory of personal data is pseudonymous data. Pseudonymous data is data that cannot directly identify a data subject unless additional information becomes available. The most typical example of pseudonymous data is personal data that has been replaced by a number. Think of it as pieces of puzzle. In this example, let's say that the identified person is Mr. John Atkins, and you want to collect his birth date. If you take security measures and replace Mr. Atkins' name with a number, the person who will have access to the birth date will just know that someone under the number 38 has his or her birthday in February. The information on who is behind number 38 is still available, but is kept separately, and only those who have access to this additional information can actually identify the relevant data subject. If the additional information is not kept separately and there is no other way from the data you collect to identify Mr. John Atkins, then this information is not personal data but anonymized data. Anonymized data is the only data that fall outside the scope of the GDPR. This means that you don't have to worry about complying with the GDPR when you collect or process in any way anonymized data. However, you need to be aware that anonymization is more difficult than it looks, and in some cases, true anonymization can never be achieved. So before you start declaring all personal data anonymized data, you need to take measures to ensure that the data subject can no longer be identifiable, and you need to always check developments in re-identification techniques that might result in upgrading the anonymized data to pseudonymous ones. So why does this categorization matters? It matters because depending on the category of personal data you collect, the risk for the rights of data subjects are higher or lower, and this reflects on your obligations under the GDPR. Special categories of data is the riskiest category, and therefore extra safeguards and measures need to be implemented on a daily basis to minimize these risks. In contrast, pseudonymous data pose lower risks, and to be GDPR compliant, less technical and organizational measures are required. As far as the material scope is concerned, the GDPR applies to any processing of personal data, wholly or partly by automated means. If the processing is not by automated means, the GDPR applies only when the personal data collected form part of a filing system. Processing means any operation which is performed on personal data, whether or not by automated means. Among others, these operations can include the collection, storage, copying, deletion, anonymization, editing, or transmission of personal data. Profiling, a form of automated processing of personal data that either evaluates or predicts personal aspects of a data subject, like his or her personal interests or health condition, is also a processing activity. Although processing is a very broad term, unless it is happening via electronic forms, the GDPR is not always applicable. Below you will find a diagram that you can use as a guide whenever you have doubt. According to the GDPR, even when processing of personal data actually takes place, there are two exceptions under which the GDPR is not applicable. According to the first exception, when personal data is being processed for purely personal or household activities, the GDPR doesn't apply. However, to fall in this category, the person who processes this data must always be a natural person, as companies, who are considered legal persons, cannot have by their nature neither personal nor household activities. The second exception applies when the processing of personal data occurs during an activity that is under the exclusive national jurisdiction of a member state. Usually this happens for national defense reasons. As far as the territorial scope is concerned, the GDPR uses two different criteria, the establishment criterion and the targeting criterion. According to the establishment criterion, whenever a company or a natural person has its establishments within the European Union, any personal data he or she or it processes must comply with the GDPR, no matter if the actual processing of personal data takes place in a third country. As the GDPR is directly applicable not only across the 27 member states of the European Union, but also across Iceland, Norway, and Liechtenstein, which belong to the European Economic Area, if you have a branch office, a subsidiary, or headquarters within these countries, and you process personal data, you need to comply with the GDPR. According to the targeting criterion, even if you are not established in the Union, the GDPR is still applicable if you process personal data of data subjects who are in the Union and you offer them goods or services, or if you're processing personal data in a way that you monitor the behavior of data subjects while they are in the Union. The targeting criterion applies regardless of whether the targeted data subject is a European citizen or not. As long as you process their data while they are in the Union, the GDPR is always applicable. In the context of Fed4FIRE+, this criterion is especially important to JFED users who access testbeds that are not located within the Union. In order to fully understand your obligations, you first need to know the key players and identify under which capacity you act in the context of Fed4FIRE+. Controllers is the most important category of key players. According to the definition, a controller is any natural or legal person who determines the means and purposes of processing personal data. As a rule of thumb, if you have decided on your own what data you will collect, how, and for which reasons, then most likely you are the controller. The controller is the number one person who is responsible to comply with the GDPR. On the other side, processors never decide on their own. They always rely on the guidelines they receive from the controller, and they process personal data on his or her behalf. However, you need to understand the difference between employees and processors. Although both of these categories process data on the controller's behalf, if someone works as an employee of a controller, he or she is not considered a processor on its own. Employees' actions are considered direct actions of the employer, thus of the controller. To become a processor, you need to be a separate legal entity and have a contractual relationship with the controller. The GDPR poses less obligations for processors than controllers. However, if, even for some part of the processing activity, the processor takes the initiative and decides on its own, he or she is automatically considered a controller for this particular activity, upgrading significantly his GDPR responsibilities. So which player are you in the context of Fed4FIRE+? If you're an experimenter and you decide to process personal data in a testbed as part of your experiment, then you are a data controller. In this case, the testbed and Fed4FIRE+ acts as your data processor. Another important player is the Data Protection Officer, or the DPO in short. A DPO is always a natural person, and he or she can be either an internal employee or one externally appointed. The appointment of a DPO usually is voluntary. However, it becomes mandatory when your core processing activities lead to a regular and systematic monitoring of data subjects on a large scale, like profiling activities, or when a large scale of special categories of data takes place, for instance, when you develop a health app. If you decide to collect personal data and you are a data controller, it is your responsibility to appoint a DPO. Although each testbed/processor has appointed its own DPO, this doesn't cover your responsibilities as a controller. The DPO network among Fed4FIRE+ aims to ensure collaboration among DPOs and maximize compliance, so your DPO will always have the necessary support. The appointed DPO has to fulfill various tasks. Internally, he or she is in charge of advising controllers or processors and their employees on their GDPR obligations, monitoring compliance, arranging internal audits when necessary, and providing his opinion on data protection impact assessments. Externally, the DPO should cooperate with data protection authorities and act as a contact point between both the controller and the supervisory authority, and the controller and the data subjects. At a high level, the GDPR doesn't set many absolute rules. Instead, it sets 7 key principles that controllers always need to comply with. These are lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, or better known as data security, and accountability. To comply with the lawfulness principle, you need a valid legal ground for each personal data you collect. In addition, you must use personal data in a way that is fair. This means you must not process personal data in a way it is unduly detrimental, unexpected, or misleading to the data subjects concerned. To achieve transparency, you must be clear, open, and honest with data subjects from the start about how you will process their personal data and why you need it. This in practice is disclosed via a privacy notice to them before you try and collect their personal data. In general, anytime you communicate with data subjects, you must write in clear and plain language to maximize the chances of them to understand. The information must also be easily accessible to data subjects. Before you start collecting personal data, you need to be clear towards data subjects on why you need it and how you will use it. When you decide to collect personal data for a specific purpose, you should ensure you do not process it for any other purpose than the originally stated, unless the new purpose is compatible with the original one. As a rule, if the new purpose is very different from the original stated, in a way that it would be unexpected for data subjects or would have an unjustified impact on the individual, it is likely to be incompatible with the original purpose. Data minimization means that any processing activity must be adequate to fulfill the stated purpose, relevant with the purpose, and limited to what is necessary. The key principle of accuracy aims to ensure that personal data is kept accurate and up to date. To achieve this, regular checks of the accuracy of personal data are needed. Inaccurate data must be either deleted or rectified without undue delay. Measures to ensure the traceability of data amendments and invitations to data subjects to check themselves the accuracy of their data are some of the measures you could take to comply with this principle. Storage limitation has a very simple rule. The shorter personal data is stored, the better. Since you do not need all types of data for the same amount of time to achieve your purpose, a retention period per each data category and per each stated purpose must be drawn. As soon as personal data is no longer needed, it shall be deleted or fully anonymized. Storage limitation has the additional benefit to cut unnecessary costs associated with storage and security, so effective implementation of this principle has more pros than cons. According to the integrity and confidentiality principle, personal data shall be processed in a way that protects it against any accidental or unlawful damage, loss, or alteration. The CIA triad explained in the diagram should be implemented throughout the life cycle of data, from the collection and dissemination to its destruction. To achieve this, appropriate technical and organizational measures must be determined on a case-by-case basis. As a controller in the context of Fed4FIRE Plus, you should not just comply with the GDPR. You should be able to demonstrate this compliance as well. At a high level, the basic steps you need to take to achieve this are the following. First, you should allocate data protection responsibilities within your team. Second, you should train your staff and implement organizational measures. Third, you should maintain detailed documentation of the data you process. Fourth, you must have contracts in place for processors or any potential international data transfers. And lastly, if it is mandatory, you should appoint a DPO. As we mentioned before, you need to establish a lawful purpose before any processing activity takes place. There are 6 available lawful grounds for processing, but in the context of Fed4FIRE+, the more relevant among which you have to choose are 1. The data subject's consent. 2. The processing is necessary for a performance of a contract between you and the data subject. 3. The processing is necessary to comply with a legal obligation. For instance, when a regional law sets out specific rules for programs on smart cities. Or 4. The processing is necessary for the purpose of your legitimate interests, unless such interests override fundamental rights of data subjects. None of these lawful bases is better or more important than others. You need to select the most appropriate one, considering the relationship you have with the data subject and the intended purpose. When you process special categories of data, a higher protection is needed. As a rule, the processing of special categories of data is prohibited unless one of the following purposes applies. 1. The data subject gave his explicit consent. 2. The special categories of personal data is manifestly made public by the data subject. 3. The processing is necessary for public health reasons. Or 4. The processing is necessary for scientific research purposes, as long as there are measures in place that can safeguard the data subject's rights, like pseudonymization. Consent is one of the most common lawful bases. However, for a valid consent, certain requirements must be met. In particular, consent has to be specific, meaning that for each purpose of processing, different consent is needed. Informed, meaning that the data subjects must have been adequately informed before they consent. Unambiguous, meaning that a clear action from the data subject must be made with no pre-ticked boxes. Freely given, meaning that the data subject must have a real choice to refuse. And easily withdrawn, meaning that data subjects must at any time be able to withdraw their consent. In addition, when explicit consent is required, the data subject must expressly confirm it in words, while documenting consent forms is very crucial to demonstrate accountability. Data protection by design and default is one of the most important responsibilities you have as a controller. According to the data protection by design principle, data protection must be embedded from the design stage through the life cycle. Privacy patterns, which are design solutions to common privacy problems, are a useful way to standardize the design process and ensure data protection by design. In addition, you must anticipate risks before these take place and take steps to mitigate the harm and minimize the chances of actual occurrence. Adopting privacy-enhancing technologies, better known as PETs, should also be considered. Data protection by default aims to ensure that by default only personal data which is necessary for each specific purpose is being processed. To achieve this, you need to set up a default configuration for all processing activities that leads to minimum extent of processing, minimum storage period, and minimum accessibility of personal data. Especially regarding accessibility, any personal data you process must be available on a need-to-know basis by default, and should not be disclosed to the public. To the extent possible, data subjects must be empowered and have the option to change the default settings after adequate information of the consequences of this alteration. In the context of Fed4FIRE+, the testbeds have already embedded privacy by design and default. However, if you as a controller decide to collect personal data, you need to ensure that this decision also embeds privacy by design and default. To that end, Fed4FIRE+ collaborates with experimenters to ensure the minimum amount of necessary information is processed during the experiments. The GDPR also grants direct rights to data subjects. These are the right to be informed, the right of access, the right to restrict processing, the right to rectification, the right to erasure, the right to object, and the right to data portability. When automated decision-making takes place, specific rights are additionally granted for data subjects. In the table below, you will find a very brief description of each of the data subject's granted rights. For instance, anytime the data subject requests you to delete his or her personal data, he or she has just exercised the right to erasure, also known as the right to be forgotten. Although usually data subjects can exercise these rights at any time, some are available only if certain conditions are met, or only when the processing relies on a specific lawful basis. Below you can find a compact overview of when each right is available to data subjects. Automated decision-making is the process of making a decision by automated means, without any human involvement. As a rule, automated decision-making that can produce legal effects, or at least similarly significant ones, is prohibited. Such decisions can include profiling, e-recruitment, decisions regarding performance at work, or assessment of a client's creditworthiness. In such cases, automated decision-making is lawful only if it either relies on the data subject's explicit consent or it is necessary for entering into a contract with him or her. Even if you establish one of these lawful purposes, under the GDPR, you need to ensure that data subjects can exercise their right to obtain human intervention, express their point of view regarding the automated decision, and that they can contest the decision. Data Protection Impact Assessments, or DPIAs in short, are used to identify and address any data protection issues that may arise when developing new products or services using innovative technologies that may result in a high risk for the data protection of the data subjects concerned. DPIAs are not always mandatory, but this has to be decided on a case-by-case basis. Under the GDPR, you must conduct a DPIA when profiling or any other systematic and extensive evaluation of data subjects takes place, when you process large-scale or special categories of data, or when you systematically monitor a public space on a large scale. Below you will find a diagram that shows the main steps you need to take when conducting a DPIA. First, you need to identify whether a need for a DPIA exists. Then you need to describe the processing in detail and consider consultation if the decision is complex. Then you have to assess the necessity and proportionality of the processing and identify the risks this entails. When risks are identified, you need to find measures to mitigate the impact and then record the outcome of the DPIA. The result of this DPIA should be integrated into a practical plan you need to start implementing to ensure the effective compliance with the GDPR. Whenever you process personal data, a personal data breach is always an imminent danger. According to the GDPR, a personal data breach is a breach of security that leads to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. A data breach can happen for various reasons, but mostly they occur due to a human error or a hacking attack. Other reasons that may lead to a data breach are natural disasters, inappropriate access controls, or equipment failure. When you, in your role as a controller, become aware of a data breach, you need to notify the competent data protection authority within 72 hours. At a high level, you should describe the nature of the breach, the categories of data, and the approximate number of the data subjects it concerns. You also need to provide the contact details of your DPO and any information on how the breach will likely affect data subjects, or any measures you have already taken or are planning to take to address the breach and mitigate its effects. Sometimes you might not be able to provide the above information within 72 hours. If so, you need to provide the requested information in phases or explain why you cannot provide such information on time. Keep in mind that in case the data breach poses insignificant risks to data subjects, for instance, due to pseudonymization measures, then you do not need to notify the competent authority, though you still need to document the data breach internally. The 72-hour deadline starts only from the moment you, as a controller, become aware of the data breach. Usually, you will be considered aware of a breach when a hacker contacts you to demand ransom, showing evidence that he or she has control over the personal data you process. When a processor of you notifies you about the breach, when a third party, including a data subject, informs you that he or she accidentally received personal data of another individual, or when your employee detects an intrusion or an error, and this is confirmed by an initial check. This diagram aims to help you identify when you need to notify the Data Protection Authority or also the data subjects. As a rule, whenever a breach is likely to pose risks to data subjects' rights and freedoms, you also need to notify them. To ensure you are well prepared, even in the worst-case scenario of a data breach, you can take certain measures to mitigate the potential risks it will pose. These, among others, include preparing a response plan for addressing data breaches, allocating responsibilities for managing breaches to a dedicated person or team, training of employees to correctly identify a data breach and escalate it promptly to the appropriate person, performing DPIAs when necessary, regularly review of the security measures and documentation of all breaches. Keeping a data inventory to quickly identify which personal data was affected and knowing the relevant supervisory authority you might need to inform is also crucial and will help you save valuable time when the 72-hour deadline is approaching. In many cases, the processing of personal data doesn't happen solely on EU ground. Many data centers, for instance, might be physically located outside the EU. Especially for JFED, the testbeds are not located within the EU, thus this chapter is particularly important. According to the GDPR, international data transfers to third countries are allowed only if the third country has an adequate level of protection or if there are appropriate safeguards in place to ensure the security of the data transfer. If you transfer personal data to a country where the European Commission has granted an adequacy decision, there is no need for you to take further measures. The map shows which countries at the moment belong to this white list. If there is no adequacy decision, you need to ensure there are appropriate and effective safeguards. To rely on these, there are three main transfer mechanisms available. You can rely on binding corporate rules only if the data transfer happens solely within your multinational organization. For instance, a data transfer between a branch or a subsidiary abroad. If the data transfer doesn't happen within your organization, then the most common option for you is to rely on standard contractual clauses. These are clauses adopted by the European Commission or a supervisory authority, and you need to insert them in your contracts with third parties. The least common option available is an approved code of conduct or a certification that includes a binding commitment of the controller or processor of that third country to apply effective safeguards. In practice, if you identify that you will transfer personal data to countries where the GDPR is not applicable, you need to follow the next steps. 1. You need to map your international data transfer to check which countries are involved. 2. You need to check whether these countries have an adequacy decision. 3. If there is no adequacy decision, you have to choose and implement the suitable transfer mechanism. And 4. You have to regularly monitor regulatory developments. For instance, if an advocacy decision has been repealed or new standard contractual clauses have been published by authorities. Lastly, you need to realize that processing is a dynamic process. Thus, its compliance should also be dynamic, and there is no one-off exercise that will make you GDPR compliant. This slide provides a checklist for implementers that summarizes your obligations during the Fed4FIRE Plus project. Thank you very much for your attention.